Good evening, everyone. I am C. Amita Vissa, moderator of the webinar. We are delighted to welcome you all to the webinar organized by Commercial Laws and Economic Advisory Committee, that is CLEAC of ICAI. The committee is ably led by CA Sanjeev Kumar Agarwal, Chairman, and Vice Chairman CA Purushottam Malji Khandelwal, whose vision and guidance continue to strengthen the role of chartered accountants in shaping commercial laws and economic advisory practice. It is my pleasure to be the moderator of today's webinar on competition law, understanding and complying with the competition law in India, scheduled today, that is 14th May 2026 from 5 p.m. to 7 p.m., organized by CLEAC of ICAI. Before we begin, I would like to briefly appraise you about the committee. CLEAC is focused on encouraging chartered accountants to shape strategy, policy that unlocks economic, financial, and social values while combining analytical foresight with commercial acumen. One of the core areas of the committee is to serve the multifunctional task of analysis and knowledge dissemination, providing inputs to regulators on policy formulation, develop and publish technical guidance and background materials, creating awareness of professional opportunities for chartered accountants in the domain of commercial law and economic advisory. It's a privilege that we have today with us the chairman and vice chairman of our committee. We are privileged to have them with us. Let me have the introduction of our chairman, a distinguished professional with nearly 4 decades of practice. He is Central Council member of ICAI and has served in numerous leadership roles since 2010. His contributions span across key committees including direct taxes, international taxation, research, legal coordination, and public finance, reflecting his deep commitment to strengthening the profession and governance framework. Under his visionary leadership, CLEAC continues to promote awareness and professional excellence among chartered accountants in the field of commercial law and economic advisory. He upholds the very important his vision is that there should be transparency, compliance, and integrity. They are the pillars of sustainable economic growth. Now it's my honor to invite CA Sanjeev Kumar Agarwal, Chairman of the committee, to kindly address the gathering. Sir, with your vast experience as Central Council member and your distinguished leadership across numerous committees of ICAI, your words of guidance will inspire and enlighten all the participants. We request you to share your thoughts and wisdom with us. Over to you, sir.
Thank you, Moderator Sajjaji. Let me first of all welcome all of you and good evening to everyone. I'm also thankful for my Vice Chairman, P. Purushottam Lal Khandelwalji, for coming in this webinar out of a very busy schedule. Let me tell you, friends, in ICAI, today I am the chairman of this committee, but next year it might be possible that I become vice chairman of Purushottam Lal Khandelwalji, either in this committee or somewhere else. So it is not the chairman, it is the chair, which is the most important thing in our institute. And we have the example of this. For example, in aggregation of CA committee, I was the chairman for last 2 years. Now in this year, I am the vice chair. Also, friends, let me tell you brief about some of the key initiatives. We do the specialized courses like arbitration, mediation, anti-money laundering law, where we had a lot of discussions with the authorities also. We do in FAMA, which is the most, you can say, envisaged course, what we are doing. We do in real estate, and also we are there in RERA also. So I don't want to take much of your time in telling you that what we have done in the past. But today, let me tell you that the opportunities which this committee is bringing to our member is immense. And let me tell you that I was not very sure when the charge was given to me, whether I'll be able to compete with my other peers, those who are in direct taxes or those who are in GST. But after 2 3 months, I'm finding that not I'm competing, but I'm also putting them behind, because the opportunity which this committee is bringing is immense. And my vice chairman itself is the biggest example of that, that he is in the mainstream of a practice which is not being popularly as income tax or GST or company law or audit. So I'm always beneficial for his deliberation. But after a long time on competition law, we have requested one of the very busy and one of the you can say expert in the company's competition law, Shri G.R. Bhatia, to spare his time and come in our forum. So with this, not taking much of the time, my vice chairman, please add some words so that we can begin the technical session. Petra, you may introduce him.
No need. No,
Yes, sir. Sir, will you go ahead?
yes,
Okay.
yes.
Okay.
Good evening, most respected Chairman of the Committee for Commercial Law and Economic Advisory, senior most in the Council, Sanjay Agrawal sir, faculty, respected G.R. Bhatia sir, moderator Amitabh Vissa ji, and all my professional brother who are watching this live webinar. Friends, we have a domain of the audit, income tax, and GST. But apart from that, there is a lot of opportunity, as Sanjay sir said, that they put behind of this. Or so the in the era of globalizations, we say that the chartered accountant is a global business solution provider. So we cannot provide a solution with this only thing, income tax audit and GST, but we are entered into merger agreement, a lot of advice to the big corporate house for the many, just like competition law. So we have a we started the series know your law. There are many law in India which is not a part of our syllabus, but when we are in the field of practice or in the corporate where we are serving, we must have a knowledge of this law is also very important. And without this knowledge, we cannot be a good professional. So I will not take much of time. Sir Bhatia sir is here. We were heard from the Competition Commission of India. It's a very important law in India. So please go ahead. Thank you, sir.
Thank you so much, sir, for your words of wisdom. Now, let me have this privilege of introducing our eminent speaker of today's seminar, Mr. G.R. Bhatia ji. He is senior partner and head competition law practice, corporate professional advisor and advocates. Mr. Bhatia brings with him more than 3 decades of experience in competition and regulatory practice. He is former additional director general of the Competition Commission of India, that is CCI, and the erstwhile Monopoly and Restrictive Trade Policies MRTP Commission. He has received international training in anti-monopoly laws from Japan Fair Trade Commission and unilateral conduct cartelization from the Korean Fair Trade Commission, Seoul. He was closely associated with 2007 amendments to the Competition Act. In recognition of his expertise, Mr. Bhatia was appointed by the Ministry of Corporate Affairs, Government of India, as an expert on the National Committee of Competition Policy. He is a sought-after speaker on emerging issues, including digital competition law, and has conducted various sessions with the Ministry of Corporate Affairs under the National Foundation for Corporate Governance Education series. He has been conferred the Mondet Thought of Leadership Awards in antitrust competition law for spring 23 and autumn 25, and he appears before CCI, NCLAT, and Supreme Court of India. We are honored to have him with us to share his insight on competition law, understanding and complying with the competition law in India. Over to you, sir. Thank you.
शेयर करूंगी, वीडियो ऑफ कर
Bhatia sir, can you
Thank you.
adjust the camera a little bit? You are not in center of the screen.
Is it all right now?
Yes, yes. Perfect.
switch off the camera.
One small announcement that we will be having question answer session. So participants are encouraged to actively participate and make their questions in the question box, and we will address that and share to the learned speaker for the solutions and for the replies of your queries.
Good evening. Am I audible and visible?
Yes.
Yes,
Right.
sir.
Good evening, Chairman, Vice Chairman, and Moderator. Thank you very much. I don't know how far it will be relevant, but as far as I see, the pink newspaper, whether it is Economic Times, Business Standard, every news item which I read, I find there is an element of competition. Every day I find that in every news which I read, there is some dimension related to competition aspect. And so competition law, as I see, is the most relevant for all of us. So while income tax may be relevant for a person who is subject to assessment, GST may be relevant only for those who trade in goods and services. But so far as competition law is concerned, I think whether I am an assessee or not, whether I am buying goods or not, I am impacted by competition in the market. So if I am not directly being impacted, my brother is impacted, my friend is impacted, my relative is infected, my neighbor is impacted, and everything which we find has got an element of competition. The moment family is blessed with a second child, the first child starts getting the heat of competition within the family. So is the case in trade and industry also. Entry barriers. The moment the new player comes, as you know, in 2016, Reliance Jio entered into the mobile service market and it shook the existing incumbent mobile service player, uh, Airtel and Vodafone. Now it has become an established player, and so now the market is shared by the three major players, Reliance, Airtel, and Vodafone. So competition we find in every aspect of life. You have read only day before yesterday that the uh, athlete federation, boxing federation, is not allowing one of the players. It's a competition issue. Then competition authorities and various sports authorities have become very vigilant about doping. If I am doped and you are not doped, and if both of us happen to be athletes, that means there is no fair competition between the one who is doped and who is undoped. So everything, so fair competition is not there. Day before yesterday, you have come across a news item that the NEET paper has been leaked. That means the competition in the examination is neither fair nor free. There is something wrong has gone. And imagine the plight of a student who has burnt midnight oil and now he finds that the paper has been leaked. So we find competition dimension in every aspect of our life, and hence the need for understanding the competition law and the need to maintain fair and free competition in market is most essential. And worldwide, every time attempt is made to scuttle fair competition. So the government of India, in line with global trend, we gave goodbye to the MRTP Act and we enacted competition law. And this act seeks to have ensure four objectives. It it frowns upon practices which prevent, which have adverse effect on competition. So every business practice is not unlawful. Every business practice is not uncompetitive, so long it doesn't have the adverse effect on competition. So only if a practice, a business conduct, a business agreement, unless it results in adverse effect on competition in market in India, it is not found under the act. Kindly remember. Then this law is meant to promote and sustain competition. I'm going to tell you shortly what are the benefits of having competition, what are the benign aspects of having fair and free competition in market. Then this law is meant for protection of the consumers. But here the consumer is altogether different. Even a commercial buyer can also be a consumer, unlike under Consumer Protection Act, where only end consumer is a consumer. But if Medanta Hospital is buying glucometer to serve the OPD patient or in-house patient, Medanta is also a consumer of those glucometers. So this law is meant to protect the interest of end consumer as well as commercial buyer of trade of other participants. If there is a dominant player, be it Google, be it Microsoft, be it WhatsApp, if they indulge in any practice whereby the small competitor is who is ousted from the market, that means there is no freedom to carry on trade. And as you know, under our constitution, there is a protection to me that I must be able to carry my trade or profession freely without disturbance from other participants. But in case there is any intervention, in case there is any barrier which is created by my competitor, that means the very fundamental right enshrined upon me by the Constitution is not being made available to me. And hence, here is a law which comes to the protection of a person whose freedom to carry on trade is curtailed or derailed by any competitor. These are the four objectives of the law which this competition law seeks to achieve. Competition in market is benign and there are palpable, benign, visible advantages. It is competition which reduces the price of a product. I happen to be a student of BCom of Delhi University 5 decades back. A newspaper of 8-page size used to be available at 3 rupees to all of us. Over a period of 5 decades, 50 years, despite so much escalation in the cost of paper, escalation in the cost of printing, escalation in the cost of ink, printing ink, despite huge cost escalation in the cost of distribution of a newspaper, the same national newspaper, be it Hindustan Times or Times of India, as against 8 pages, as against black and white color, after 5 decades, I, as an ordinary innocent reader of newspaper, gets newspaper at a very, very comfortable price, despite escalation of so many ingredients, input which go into the publication of a newspaper. In Sri Lanka, a newspaper of the almost half size of what I get or you get is made available at almost at 15 to 18 rupees. And so is the position in Pakistan. So it is competition which reduces the price. Wherever there is no competition, you will find price will be abnormal, price will not be competitive, price will be exorbitant. It is competition which improves the quality of a product. It is competition which boosts the choice of a consumer. Now, with the entry of the Reliance Jio in the mobile service market, I have got my option, my choice has gone up. As against two player, now I am having a choice whether I can avail of the services from Reliance or Vodafone or from Airtel. It is competition which facilitates better governance. I have been a resident of Delhi, and 4 decades back, there used to be only one supplier of milk, Delhi Milk Scheme. So For fetching a bottle of a milk, you necessarily need to have an 80-year-old person in your family who can keep bag at the milk booth to fetch milk at 6:30 a.m. Now we have the government has introduced competition in the milk market. In Delhi, we have got a multinational Britannia is available. So a small player Nanak Milk is available. A cooperative society is there, and then there is a government supplier. Mother Dairy is also there. Amul is also there, which is run on cooperative basis. That means the governance by government. It is the government which was fixing the price. It was determining the price of milk. It was the government which was determining what quantity and of what quality milk will be given to me. All these now have been left to market forces, and hence the governance has become much easier than what it used to be 3 decades back. It is competition which promotes efficiency. And you see that recently, now with the setting up of Noida Airport, now there is a competition to Indira Gandhi Airport at Delhi. And of course, so both their debates are going on that whether the airline should avail of the facility of Noida Airport or only Indira Gandhi Airport. And incidentally, let me tell you that till Noida Airport was not there, there used to be an allegation against Indira Gandhi Airport that for hangar charges, for landing charges, off-take charges, Indira Gandhi is taking the highest, their charges are highest in the world. Why? Because there is a monopoly. And who are the victims? Victims are airlines who happen to be consumer of the services made available by the airports. Hopefully, with the competition from Noida Airport, maybe things will improve and the consumer, airlines, and other who avail of the airport facility will have a better deal. It is competition which encourages innovation. In areas where there is no competition, you will find lack of innovation, lack of invention, no investment in R&D. You know it that under tuberculosis eradication program, it is invariably the government, either central government or the state government. It happens to be the buyer of tuberculosis medicines, and the resultant impact is, since remunerative price is not made available to the pharma companies, there has been absolutely no innovation so far as uh, uh, prevention of tuberculosis is concerned. As against that, you will find that wherever there is no regulation of price in relation to lifestyle diseases, there have been continuous innovation, there have been continuous research and developments, and improved quality of medicines, improved quality of and more efficacious systems are being made available. So we need to encourage competition, and because the resultant impact is better innovation. It is competition which punishes the laggards, which punishes the defaulters. If you happen to be an inefficient player in the market, you can't survive long. And for survival and for thriving, you have to make yourself innovative, efficient, and competitive. It is competition which ensures triple A, and triple A means you are that the goods are made available in abundance of acceptable quality at affordable price. If in our Indian economy we need to have goods in abundance of acceptable quality at affordable price, we need to have competition in the market. Having said so, and let me invest 2 minutes on this logo which we have evolved for the Competition Commission of India. These flames, they are of blue color, which is a sign of prosperity, and they are showing upward trend. That means they bring growth. And I refers to industry, that means economy. So this law is meant for growth. And incidentally, if you kindly go to the website of OECD, and if you go to the antitrust division of OECD, you will find a slogan: competition brings prosperity. Competition allows prosperity. So there is a direct linkage. They show it with the prosperity of an economy. So you can imagine the efficient, the impact, the benign side of having competition in the market. Now, having said that, competition in market is so good, so much needed, but why is it that we don't have competition in the market? There are certain unique feature of competition, and one of the unique feature is that no one wants competition in his or her own field. Tendulkar doesn't want, Virat Kohli doesn't want a competitor. I also don't want to have a competitor. I want to be the only single competition law expert in my own firm and in India and in Delhi. So it is a human nature. No one wants competition because in competition you have to pull up your socks, you have to meet burnout oil, you have to perform better than what you did yesterday. So human nature is against fair and free competition, and competition is unstable. Today I am performing well. If I don't continue with the practice, if I don't continue with improving myself, I will not survive, I will not thrive in competition. Competition kills competition. Many a times competition is so stiff that itself kills the competition. And there is an immense allurement to violate the law. And that's what is the problem which worldwide it is being debated, that high-tech giants, they are they have there is so much quick results that they can there is a huge allurement to violate this antitrust law. And hence we need to have law as well as an umpire. And so far as umpire is concerned, this law is primarily being implemented by the Competition Commission of India, Competition Act, and the rules framed thereunder and the regulations and formulated by the CCI. They govern how competition is to be maintained and how action can be taken against a violator of this law. More than 125 countries in the world are having their own antitrust law. This itself shows the need for and relevance of having antitrust law in every economy, including in India. And that's why way back in 2002, Government of India thought of giving goodbye to the MRTP Act and to come up with a new law which is in line with the global trend of the antitrust law framed by the major or matured jurisdiction of the world. Now, there are three dimensions of this law, and one of the major dimension is anti-competitive agreement. I have told you in the very beginning that everything is not bad. Every practice is not bad. Only that practice which has got an adverse effect on competition is frowned upon under the competition law. So one major relief you should note is that it's not that every agreement you enter into is regulated, it is governed, it is disciplined by the competition law. Only that covenant, only that clause of the agreement which hits competition in the market can be frowned upon, can be objected to by the Competition Commission of India. Then in case you happen to be a lead player, you are a dominant player, as in the search engine market, Google happens to be a dominant player as per the assessment made by the CCI, or DLF happened to be a dominant player in the real estate flats in the range of 2 to 2.5 crore way back in 2013-14. That means DLF was dominant in the geography and the Gurgaon territory, in the Gurgaon geography. And so if you are dominant, then dominance is not per se bad. Only if your conduct is erratic, it is if your conduct falls in one or more of the abuses which are mentioned in the law, only then it can be, the competition regulator can frown upon you. So kindly note, merely that I am of a big size, merely that my market share is huge, I can lead the industry, does not give rise to any competition concern, so long my conduct is not objectionable. It is just on the analogy of a traffic norms. Drinking is not bad, but driving and drinking is bad. So dominance is not bad, but if I am dominant, then I cannot abuse that dominance. That you kindly remember. So these are ex post. It is regulated. That means absolutely there is no need to file agreement. Absolutely there is no regulation so far as dominance part is concerned. But if when you are doing your business and you are found to have violated anti-competitive provisions, or you have indulged in abusive conduct, and in case you happen to be a dominant, the competition commission will take action ex post. Before that, no approval is required, no permission is required. But if subsequently your conduct is found to be either of the dimension of the competition law, competition commission can take action against you. Ex ante regulation of combinations. If certain combinations, certain mergers, certain acquisition which crosses the threshold as prescribed in the law, you are required to take prior approval of the competition commission, and that's why it is ex ante regulation. Why ex ante and why not in case of anti-competitive agreement and AOD? Why ex post provision exists in case of mergers or acquisitions? If subsequently action is taken by the competition commission, that means post combination, if action is taken, it becomes very difficult to bring back the corporate enterprises to the same position. It is just like I can have made omelette out of the egg, but once it has become an omelette, then I cannot reconvert into egg. So is the case of combinations. Once combination takes place, interest of third parties stands created, and hence it becomes very difficult to take corrective action later on. That's why worldwide, and so is the case in India, that so far as combination, mergers and acquisitions are concerned, they are regulated ex ante. Another dimension of this law is that, worldwide, and so is the case in India, government happens to be government laws, government procedure, government regulation, procedure and laws of the statutory authorities, municipal corporations, all sub-state arms of the government. They evolve policies, rules, and regulation, and invariably it is found that they do give rise to competition concern. And in case government or government sub-states, they want to come up with they want to get reviewed any existing or forthcoming or future policies or rules or regulation, they can have advice from this Competition Commission of India to the effect whether it is going to give rise to competition concern or not. This advice is given in a time-bound manner. The last dimension, a statutory obligation which calls upon, an obligation which devolves upon the CCI and including all authorities, including Institute of Chartered Accountants, to create awareness about the uses and benefits of having free and fair competition in markets. So I see that the webinar which Institute of Chartered Accountant has now organized. Thank you very much to this Commercial Advisory Committee of the Institute of Chartered Accountant, because you are performing the function which devolves by law, because advocacy is one of the dimension of competition law. And today's webinar is in this direction. Now you need to be told what is the structure and which are the authorities which implement or are relevant so far as execution of this law is concerned. So the Competition Commission of India is the sole authority, sole national authority in India to implement the provision of the competition law. And then Competition Commission of India is assisted by an organization by the name Director General Competition Commission of India. Director General is an institution which has a responsibility to assist the CCI in the carriage of the investigation. While Competition Commission is the deciding authority, adjudication authority, but investigating arm is the Director General Office. And in case I am unhappy, I am aggrieved of the order passed by the CCI can file an appeal before the NCLAT. And if again I am unhappy with the order passed by the NCLAT, I can file an appeal before the Supreme Court of India. But a unique feature which this law has, which we were not having before with the MRTP Act, and this power was not with the MRTP Commission, was that the current Competition Commission of India law permits the CCI to enter into MOU, Memorandum of Understanding, with the competition authorities of the overseas jurisdiction. And let me tell you, sir, that the Competition Commission of India has entered into MOU with the FTC, Federal Trade Commission of US, with the European Commission, with the Japanese Fair Trade Commission, with the Australian Competition and Consumer Commission, and several other major trade partners of the Competition Commission of India. And the advantage of this MOU is to share information, share knowledge, have transparency, and these MOU also helps in evolving, in adopting, in carrying forward the best global practices, and this enables the Competition Commission of India to align its practices, to align its decision with the matured overseas jurisdiction. And incidentally, you take the example of Bridgestone. Now, Bridgestone or Michelin Tire operates in over 120 countries in the world. So if there is a Bridgestone South Africa company, if it indulges in some objectionable trade practices, there is likelihood that Bridgestone India may also be indulging in similar type of practices. These MOU comes as a very helpful tool in detecting and busting such kind of arrangement in India. Now, there are few terms, sir, which are very relevant. I will not be able to explain each and every one, but some of the important terms. One is agreement. Often we feel that agreement वही है जो written agreement है, formal agreement है. No, not at all. So far as Competition Act is concerned, whether an agreement is oral, unwritten, if it is not an agreement, it is just an arrangement, just an understanding, it is just a nod or some kind of thumb you have given. So any kind of indication, suppose I sent you a WhatsApp message and you just thumbs up, it is an agreement for the purpose of competition. So you can't take the plea or excuse, sir, where is the formal agreement? So any arrangement, and as you know, I'm going to disclose you that most of the time, bid rigging cases, cartel cases, there will be always evidence will be hidden. It will be under the carpet. There will be no explicit clause, but the circumstantial evidence will be so strong, which will give a clear indication that there is some understanding, there is some arrangement, there is some action in concert. And so all these cases will fall within the scope of the agreement as defined under the competition law. So kindly don't be under impression, even if the agreement or contract is not enforceable by law, yet under competition law, it will be treated as 100% perfect agreement for the purpose of implementation of competition law, and it will be subject to the discipline of competition law. Then another term is cartel. Invariably, there will be absolutely no direct evidence. And I will, in subsequent slide, I am going to tell you how circumstantial evidences are relevant so far as proving a case before the competition commissions are concerned. Enterprise is extremely relevant. Government department, public sector undertaking, private sector enterprises. So irrespective of where you have been incorporated, irrespective under which law you have been incorporated, irrespective of the fact whether you are a profitable non-government NGO or non-profit organization, it hardly matters whether you have been incorporated under Section 8 of the Companies Act, whether you are incorporated as a trust or as a society. You are an enterprise if you are directly or indirectly engaged in economic activity. So enterprise is very widely defined. Government department, if they are engaged in any economic activity, they will be treated as enterprise. So here is a change under from the MRTP Act to Competition Commission. Under MRTP Act, government enterprises, government departments were not covered, but now government department is also covered. Ministry of External Affairs, if it is engaged in any economic activity, that will be an enterprise for the purpose of competition law. Only 4 government departments are not covered, and those departments are Department of Atomic Energy, Department of Space, Department of Currency, and one more department. They are not subject to the scope of the competition law. Other than that, all government departments are subject to the control of the discipline of the competition law. Effect based and consumer, I have given you already a flavor that even if you are a commercial buyer, so if I am buying car for my own use, I am a consumer. If I am running a taxi service and I am buying car, again, if there are any issues, I am a consumer of that car company, and that I can take action if there is a case of anti-competitive agreement or abusive conduct against that car company. Effect-based approach, sir. This is most relevant, sir. Lufthansa is registered in German. Similarly, many pharmaceutical companies, they are based out either in US or in Europe. But if the effect is on Indian soil, if the adverse effect on competition of that pharma company is on Indian soil, action can be taken by the Competition Commission of India. Likewise, if I am engaged in export business and due to that export business, that exporting company is engaging itself in either cartelization or in abusive conduct, and the effect is on that export destination, then that competition authority of that destination can take action, because worldwide competition or antitrust laws are based on effect-based approach. So if I am exporting to Romania and in Romanian markets, I am creating some disturbance or there is an element of uh, breaking of fair and free competition norms, Romanian competition authority can take action, and I can't take the plea that I am an overseas entity and I am not subject to your decision. Exclusion of jurisdiction of civil courts. This is most exciting dimension of the competition law. All courts in India are debarred. They are barred from taking any case, admitting any petition in which there is an element relating to competition or in respect of which action can be triggered under the Competition Act. If action can be triggered under the Competition Act, all, whether it is a High Court or a District Court or a Supreme Court, they cannot take up that, they cannot admit that petition if it lies within the jurisdiction of the Competition Act. Now, for agreement also, sir, you have to be, no doubt, I have explained that it has got very wide connotation, wide scope. But agreement, yes, it includes arrangement, it includes understanding, it includes action in concert, and and it need not be in writing, and understanding. And even if the agreement is not enforceable by law, yet it will be treated as an agreement. But then, why it is so important? Why does agreements are regulated? The importance lies in the fact, sir, more than 98% of the commercial transactions worldwide, and so is the case in India, are carried out through agreements. But good part is not all agreements are bad. Only agreements that relate to, and agreement must relate to production, supply, or distribution of goods. If the agreement relates to research and development, it is not covered under Section 3. It is not examined under Section 3 anti-competitive agreement of the competition law. And there are certain essential conditions. Agreement has to be, and there must be two parties, and the parties must be independent of each other. Now I'm talking of horizontal agreements. Horizontal agreement means agreements which are entered into between people, between enterprises which are engaged in same or identical goods or services, which are engaged in the same business. For example, ACC, Ambuja Cement, JK Cement, JP Cement, all of them are making grey cement. If there is any agreement entered into between these four cement companies, or then there are tire companies, there is MRF, there is Apollo Tire, there is JK Tire, and there is Seat Tire. All these companies, they make truck tire, they make car tire, they make motorcycle tires. If they enter into any agreement, that is a horizontal agreement. The relationship between the parties is that of a competitor. And often agreements are entered to restrict competition, leading to collusion or to gain an unfair advantage. Generally, such agreements are informal and are not in the nature of understanding or arrangement, many times facilitated by exchange of competitive sensitive information, and there is a presumption of appreciable adverse effect on competition. For example, I have given you that there are four tire companies. They formally or informally enter into some understanding or arrangement that hereafter we will reduce 15% tire production of a particular category. That means you are limiting the production, you are controlling the production in coordination with each other, in discussion with each other. That means reduction in the production. Obviously, it is with the intention to firm up the price of tire. It will be a horizontal agreement, and it can be examined, it can be looked into by the Competition Act under anti-competitive practices. And if it is a horizontal agreement, and if it is of a category which is specified in the law, then they are presumed to have appreciable adverse effect on competition. So there is a presumption by law. And incidentally, in my first slide, I have already mentioned you that under this law, all those business conducts which have got adverse effect on competition in market, they are objected to, they are prohibited under this law. Now, there are vertical agreements. Vertical agreements means which are, in the case of horizontal merger, the relationship is that of competitor. In the vertical agreement, sir, there is a relationship of buyer and seller. Maruti Udyog Limited manufactures car, then it appoints Competent Motors in Connaught Place as a distributor, as a stockist. This is so one is maker of car, one party is maker of car, other party is a distributor of car or a stockist of car. So they are not competitor to each other. They are in vertical relationship. Maruti sells to Competent Motors. Competent Motor is the buyer and Maruti Udyog is the seller. So there is a relationship of a buyer and seller in vertical agreement. And it is prohibited only, and it is not objectionable. There is no presumption in vertical agreements, but vertical agreement can also be frowned upon by the competition regulator if it results in abuse, if it results in appreciable adverse effect on competition in markets in India, and it is judged by rule of reason. That means there is no presumption. But if you can demonstrate, if the competition commission can prove that no doubt it is vertical agreement, it is between buyer and seller, but it has got huge impact. It immensely impact the fair competition in the market. There is huge adverse effect on end customer. That means appreciable adverse effect on competition. That means AAEC is there. It can be objected to. It can be cease and desist order plus penalty can be imposed by the Competition Commission of India. Uh, Generally, in vertical agreements, the choice of a consumer, or there is a case of denial of market access, or the freedom to carry on trade is curtailed. For example, I am the CEO of LG Electronics. I sell washing machines. I appoint a stockist in South Extension Part 1, New Delhi. And in there is an agreement between LG India and South Extension stockist. In that, I insist a clause that you will not compete, you will not keep competing washing machines models in your showroom. That means I am not allowing my stockist to deal with competitor. So if this agreement is there, sir, there will be what will be the implication, ramification of such agreement. That means exclusive dealings with a particular dealer. So if I am a resident of South Extension or a neighbor, or I am residing in an area close to South Extension, I as a consumer, I am interested to buy a washing machine. I find only one brand, LG. I don't find other brands available in South Extension. Resultant impact is that my choice is seriously curtailed. Now, suppose I am a CEO or CFO of BPL India, and I want to enter into, and I want to appoint a stockist in South Extension, and I go to South Extension market. I talk to the same authorized dealer of LG India. I say, why don't you keep my washing machines in your showroom? His answer is, sir, I'm happy to have your machines, but my problem is LG is insisting, and he has taken a promise from me in writing that I will not deal in competing products. That means here is a private agreement which comes in the way. So it is objecting to the law, and it is denying entry of BPL India washing machines to enter into South Extension market. So there is a entry barrier, there is a denial of market access to another participant in the market. And I come take back you to the aims and objectives of the law. If the freedom to carry on your trade is seriously curtailed, that means it is giving rise to competition concern. Then it affects the freedom of trade, and I have already explained you. So when there are exclusivity, when there is a tie-up sales, it results in either reduction in the choice of the consumer, denial of market access, or there is freedom to carry on trade is curtailed. I have so far given you example of traditional markets. Now I take you to high tech giants market and how they play. You take the case of Google. Google say if you want to buy any app from my store, you have to make payment only to Google via Google Pay. And so that means there is Bharat Pay, there is Razor Pay, there is a UPI system, there is various other modes of making payment. But my choice, I want to buy app, and I'm being dictated that you can make payment only via Google Pay. And the other implication is that other payment mode and other players in the same relevant payment market, they are being denied access by Google. And Google happens to be dominant so far as search engine and app store business is concerned. So this is an example just to explain you the concept in the high-tech markets. And that's why debates are going on in India that instead of exports regime under existing competition law, so far as regulation of high-tech giants are concerned, since the they are having immense quick adverse effect on competition, they need to be subject to ex ante regulatory mechanism and not ex post regulatory mechanism. So this is a table, sir. If there is a if the market arrangement is like this, if there is a raw material supplier, say copper is produced by A, B, C, and manufacturers are electric wire makers. So if there is some kind of collusion, some kind of coordination amongst the supplier of copper, which is one of the ingredient to make uh, electric wire, that means this collusion between and amongst raw material of copper, it is going to have adverse effect on the cost of the manufacturer. And if my input is at cartelized price, how can I be competitive? I can make available goods or services at affordable, at competitive price, both in the domestic market as well as in the overseas market, export market. Similarly, once manufacturer appoints a wholesaler and wholesaler has become the owner of those goods. I have given you an example of Maruti Udyog Limited, and Maruti Udyog sells cars to Competent Motors, Connaught Place dealer. Now, Competent Motor has become the owner. The ownership vests in Competent Motors after it has purchased cars from Competent. But if at what price and how much trademark and how much discount it will give to Mr. Bhatia or to you, if that is regulated by Maruti Udyog Limited, that means Maruti Udyog Limited is indulging in resale price maintenance. It is just like an ordinary person, sir. I sell my car to the moderator. Now moderator has become the owner. Now moderator further wants to sell the car, and in the sale agreement which has been entered into between Bhatia and Madam Moderator, if I stipulate that you will not carry 5 passengers in the car, or you will sell it, you will not sell the car below this price. This means I am making a serious dent into freedom of moderator, madam, insofar as car purchase is concerned, and it is objectionable under the competition. Now, there is another concept which is of great importance for you, sir, that is hub and spoke. And as you know, in a cycle tire, we find hub and a spoke. So, hub is the central authority, and it is hub which dictates its spokes. That means manufacturer or a trade body invariably. So, up till 2023, though the competition authority used to frown upon such kind of arrangement, but now from 23 onwards, this provision has been made now explicit in the law. Many times trade association, trade bodies, or some third agency, common agent, they act and they dictate how the spoke will function. If that is the relationship, both hub as well as spoke. So hitherto, the condition was that the parties must be engaged in identical business or in the same line of engaged in same line of business, or must be producing same kind of goods or services. Now, this concept has been further amplified or improved upon, and now even if hub is not engaged in identical trade or business, yet it can be a part of bid rigging or cartel if it is dictating how spoke will function. And there have been several cases before the Competition Commission. The e-commerce players like Amazon, Flipkart, they invariably dictate their distributor, their dealers, how they will conduct themselves, how they will do their business. Their activities are controlled. So those arrangements are in the nature of hub and spoke, and they are also form part of the anti-competitive agreements. So here I will show you a cartel video link. Kindly listen.
Stop. Cartelization is punishable under competition laws. Your collusive business arrangements may lead to severe punishments. For more information, log on to www.cci.gov.in.
So you will find that there is no formal arrangement. They were hitherto selling at different prices. They informally met. They agreed to have price parallelism. And so there is meeting of mind on a particular price. So it is a clear case of cartel. Now, as you know, bids are in government undertaking, public sector undertaking. They are increasingly required. So based
That video is going on in background. The voice disturbance is coming.
ठहरिए, कार्टेल प्रतिस्पर्धा कानूनों के तहत दंडनीय है.
Now it's okay, sir.
Okay.
But your
Thank you.
screen is not visible. PPT is gone, sir. Yeah, now it's okay. Slideshow mode can.
Bid rigging is another dimension of coordinative action. Invariably, potential bidders, they join hand together and they decide either not to bid or boycott the tender, or they offer tender bid in such a way that either the quotation is too abnormal, too low, or too high. So, if in any manner the potential bidder is manipulating the process of bidding, it is objectionable under section 3.3, and it is treated as presumed to have appreciable adverse effect on competition. So I will show you a slide relate this picture of bid rigging also.
See, there is no point fighting among ourselves. If we act in a wise manner,
Is it voice coming?
all of us can benefit from it.
But how?
See,
Yes, sir.
each one of us wants to grab the tender for himself, isn't it?
Yeah, so
So everyone will get the tender.
really how?
We are the only 3 parties empaneled with the department. So let us quote identical rates to the department.
Got it. This way, all of us would get equal work.
That's right. You're a very smart man.
You are not being wise, rather you are fools. Forming such a cartel is liable for action under Competition Act. If found guilty, Competition Commission of India can impose penalties up to 10% of the average revenue for the past 3 years. Healthy competition, good for all.
Ma'am, is it all right now? Any voice coming?
No, sir. It's all right.
Right. So I think this I have already covered. I have spoken enough. I will show you one slide here again.
So, what is the agenda of the meeting today?
To fix prices. See, we are the 3 largest manufacturers of this sector. But we've been forced to reduce the prices of our
So
products
this is
instead
a
of
plenary
increasing them.
session
But to protect the
too,
customer,
wherein
we
we are
have to
going to
reduce
be
prices.
looking
If
into
you
these
reduce
new
the price,
issues
then
in
we
the
will also have
competition
to do
law
the
and
same. And who
policy,
loses? All of us.
especially
So
with
you
regard
suggest,
to the
what should we do?
If we come
digitalization
together
of
and fix the
markets
price for
and
our
with the
product,
advent of
we can
emerging
maximize
technologies.
How come?
This
See, if I charge
session
an arbitrarily high
invites
price
once
from the
again a
consumer, he will go to
collaborative
you.
approach, a
But if
collaborative
you also
effort
demand the same
among the
price,
BRICS
then the
nations
customer will have
to
no
foster
option.
a level playing
In that
field
case,
in the
he will
global
have to buy our
marketplace
product at
to
high
encourage
price.
competition, to
prices of a
facilitate
product or a
knowledge
service by
sharing,
forming a
eliminate
cartel is a
barriers
gross
which are
violation
imposed
of the
by the tech
Competition Act.
giants,
If found
promote
guilty,
fair
the
trade,
Competition Commission of
enhance
India can
consumer
impose
welfare, and ensure transparency in the digital
of the
markets.
turnover
We
of
are also
whichever
going to
is
be
higher
discussing
for
in this
each year of
how the
cartelization.
antitrust authorities respond to these challenges, sharing lessons from their experiences. That's going to be very crucial as we navigate the
So I have divided agreements into 2 compartments, horizontal agreement and vertical agreement. So if horizontal agreement, as I mentioned, these are entered into between and amongst competitors, invariably blessed by third parties like trade bodies, like common agents, etc. And if the agreement relate to fixing of price directly or indirectly, or if the agreement relate to limiting or controlling of production, or if it is relating to allocation of market. Allocation of market means one tire manufacturer decides that I will sell in Punjab, another tire maker says I will sell in Uttarakhand, third one says I will sell in Haryana, and fourth one says I will sell only in Delhi. If such kind of allocation of market is there, or allocation can be on the basis of customer also. In tire industry, there are 2 type of customers, OEM and ordinary customer like you and me. I will buy it, so it will be treated as a case in the replacement market. I buy car, I am getting car along with tires. So after the use of 2-3 years or 4 years, I will be requiring to replace the tire. So I am a customer in the replacement market. And then OEM is, suppose I am a CEO of Maruti Udyog Limited, and Maruti Udyog Limited as a maker of cars, I am requiring cars. So there can be an arrangement for supply of tires to OEM and for supply of tire in the replacement market. If 1 or 2 tire companies decide we will only supply to OEM and we will not supply in the replacement market, and the other tire manufacturer says I will work only in the replacement market and not in the OEM market, that means there is an allocation of customer. So if there is an allocation of markets on geographical basis, on territory basis, or on customer basis, this is also an horizontal agreement. It's in the nature of cartel. It is frowned upon under the competition law. And then the 4th category is when bids are invited and you collusively either rig the bids or you give identical price, or you don't participate and you boycott the tender, you don't give the bid at all. All these categories, all these types of agreements with competitors are presumed to have appreciable adverse effect on competition. And why they are presumed to have adverse effect on competition? When I am determining along with my competitor to fix a price of a tire, that means I am not I am not agreeable, I am not inclined to compete on price. So far as you and me are concerned, both suppliers to me, they have agreed not to compete on price. That means it is obviously having adverse effect on competition in the market, because I am having no choice. Price happens to be same, and other condition will also will be prejudicial to my interest, and hence that's why they are construed as having AEC. So far as vertical agreements are concerned, vertical agreements could be in the nature of tie-in. Tie-in means uh, invariably along with, so tie-in requires two things. There should be two products. And when a supplier imposes a condition on the purchaser that if you want to buy this product, you have to necessarily buy another product. That means there is tie-in arrangement. It is just like when you buy a refrigerator from any of the company, and that company is insisting you to enter into annual maintenance contract on the date of purchase. That means there is tie-in arrangement. Tie-in arrangement, why? Because refrigerator is one product and AMC is another service. It is unrelated. The AMC contract will get triggered after 1 year, after the expiry of the warranty period. But this man, Godrej or any other company or Kelvinator or any refrigerator manufacturer, if they are insisting that warranty agreement shall be entered into on the date of purchase, that means there is a tie-in arrangement and it is objectionable under the competition law. Exclusive dealing, that if there is an arrangement between manufacturer and a stockist, that either stockist says, I will be the only stockist in Delhi, there you will not appoint another stockist, or the manufacturer says that you will be only dealer in Delhi and you will not keep competing products in your showroom. That means there is an exclusive dealing, and it is also objectionable, but not per se, only if it results in appreciable adverse effect. So in such type of situation, a burden is cast upon the CCI to prove that these vertical arrangements are having appreciable adverse effect on competition. And generally in a situation where manufacturer is having huge market share, lead market share, only in those situations appreciable adverse effect condition is fulfilled. So these are not per se bad. There is no presumption of appreciable adverse effect. An obligation is cast upon the CCI to prove that a particular kind of vertical arrangement has appreciable adverse effect. So they are not as bad as horizontal agreements are. Now, recently, there has been a case before Honorable Supreme Court, and where the Honorable Supreme Court has held that even if the bids have been invited, bids are identical, and there is enough proof that they have coordinated and they have cartelized, still the duty is upon the Competition Commission of India to prove that such collusion, such coordination has resulted in appreciable adverse effect on competition. So up till this 2019, Competition Commission was going with per se approach, but with this judgment of Honorable Supreme Court, now through the decisional practices, no doubt presumption is there of appreciable adverse effect, but the charged parties, if they can demonstrate before CCI that it has still benign impact and the adverse effect is not appreciable, it is either insignificant or the advantages outweigh the disadvantages, then Competition Commission cannot pass cease and desist order and cannot impose penalty because cartel is proved only if three conditions are fulfilled now. One, that it enters into there is an arrangement between or amongst competitors. Secondly, it falls in one or more of the categories mentioned in section 3.3 of the act. And thirdly, it has got adverse appreciable effect on competition in India. Now, as I mentioned, sir, that such arrangements are generally, the evidence is not in writing. There is no such invariably, no such formal arrangement or agreements are found. Now, how to bust, how to break, how to detect such kind of arrangement? So, in line with the global trend, so our competition law also provides for a leniency mechanism, a mechanism of whistleblower. If I happen to be a member of cartel, and subsequently, I realize that perhaps it will be advisable that I should leave my friends and I should become friend of the competition commission. So that means you want to come under leniency. And why leniency? Because no doubt I have not so far mentioned you about the penalties which CCI can impose. But before that, let me sound with that penalties are huge. Penalties are both on the delinquent enterprise as well as on the delinquent individuals. So this law has got unique provision. It not only bites, it bites bitterly, and the penalties are not only payable by the enterprise delinquent entity, but also by the individuals who have contributed to the violation of competition law. So if you happen to be the sales director or CEO or the managing director, and if it is proved that you had complete knowledge and this cartel was going on under your nose, still you have not taken any corrective action, you can be hauled up and a penalty up to 10% of the income which has been shown in your ITR. Penalty to that extent can be imposed and there will be no indemnification by the employer. Indemnification means there is no reimbursement. It has to go out of your salary. That's what the provision I am going to tell you in subsequent slides. But so coming back on leniency is that you must make, there are certain preconditions, and precondition is that you must make full, true, and vital disclosure of a cartel to the CCI. So you break the rank, you leave the friendship, and you become you change your position and you become an approver so far as other cartel members are concerned. A successful applicant, if you are the first in number, you are the first to approach the CCI, that means you are first applicant of leniency, you can be given concession up to 100% of the leviable penalty. If you are the second applicant, you can be given concession up to 50% of the leviable penalty. And if your number is third or subsequent one, then you can be given concession up to 30% of the leviable penalty. And there is a time limit also. Leniency can be filed before submission of the investigation report by the Director General. That means if you are after the receipt of the investigation report, if you are then seeking leniency, no leniency is possible. Law does not permit. If you want to have leniency, leniency can be given only before receipt of investigation report. The more you delay, lesser will be the concession which will be allowed to you.
May I come in, sir?
Come in, come in.
Good morning, sir.
Good morning. Please sit. The person who just left, isn't he competitors GM sales?
Yes, sir. And he gave a very good proposal. Sales will increase.
Really? How so?
Basically, we want to do away with competition in the market. They will work in the South District and we shall work in the North. Dealers' commission will be fixed by us. We can dump products in each other's territory just for show.
Do you even know what you're talking about? See today's newspaper. What you're proposing is anti-competitive. We can neither fix the price nor divide the market like this. The competition law strictly prohibits such practices. The company might face legal action. And then brand and reputation will also be harmed. Do one thing. Please refer to CCI's website for competition compliance manual. We may frame our own competition compliance manual that complies with the competition law so that our business activities remain within the framework of competition law. The CCI manual contains the do's and don'ts for healthy business environment.
Okay, sir.
Good.
New India thrives on fair competition. Let us join hands to fulfill this mission.
So I have already explained you tie-in arrangement. I have explained you exclusive dealing arrangement, exclusive distribution. Same if distributor asks for exclusivity. And incidentally, why they are not per se bad? When there is an exclusivity, it brings efficiency. There can be certain advantages of having an exclusive showroom. And hence they are not per se bad. But in case it results in having appreciable adverse effect on competition, the relevant market, then it can be frowned upon by the Competition Commission of India. Similarly, refusal to deal without rhyme and reason, without commercial justification, there is a stockist and you stop supplying to them. So, competition provisions can get triggered in case on arbitrary grounds you have refused to supply to a particular distributor who has been dealing with your products. Resale price maintenance, I have already explained you. Once you have sold the product, the ownership vests in the buyer, and despite the fact that ownership vests with the stockist, with the dealer, yet you control the price at which the dealer will sell to the end customer. If you are indulging in such kind of practices, it will be a case of resale price maintenance and objectionable under the competition law. Now, trade association is another limb which is extremely important so far as coordinated action by the
English, channel 2 for Russian language and channel 3 for the Chinese language. After having used the interpretation device, you're requested to kindly leave it at your respective seats and we'll accordingly take it from there. You may leave it at your respective seats. Ladies and gentlemen, this year it stands extremely important for us for
Meanwhile, we request participants to put up their questions in Q&A. We will take up it at the end of the session.
Amita ma'am, sir got disconnected or what?
His screen got free, some voice was coming, so now it's visible. The screen has come.
Okay.
So, trade association is, ma'am, am I audible and visible?
Yes, sir, you are audible and visible.
Okay.
Background noise is also not there.
Okay. So these trade associations, and I will, I think, explain you all these three cases. Chemist and Druggist Association. And why I'm mentioning you? Because recently we have argued this case. Throughout India, there are chemist and druggist associations. They invariably prevail upon the pharma companies that you will not appoint another stockist unless no objection certificate is received from chemist and druggist association. For example, I am a resident of Gurgaon, and in a particular locality, there are, say, two distributors, two stockists are there. Another pharma company wants to appoint another stockist. They say that you can appoint the other stockist only after obtaining no objection certificate from the association. See the kind of indulgence. Similarly, when new drugs are prepared or made by the pharma companies, Chemist and Druggist Association, they used to direct the pharma companies that you pay this much as product information service charges, otherwise our chemist will not keep this medicine, new medicine, on their shelf. The Chemist and Druggist Association also used to dictate trade margins, which will be given to the wholesaler, which will be given to the retailers. So the trade association was dictating pharma companies. So as I mentioned, the object of this law is freedom to carry on trade. But the freedom of pharma company, so far as appointment of stockist is concerned, so far as introduction of new product is concerned, so far as trade margin is concerned, those are prerogative of the manufacturers and not of the chemist and druggist, that means stockist association. So from time immemorial, from long time, now these practices, we feel that they have come to an end and adverse order plus penalties have been imposed. Then there is another matter of tire cartelization. So there is a tire association, and so they used to collect information about production, supply, distribution. And so the competition authority passed an order that trade association will not engage so far as compiling, collection of data which is competitive sensitive will not be collected and collated by the trade body. Similarly, several inquiries are going on against the cement manufacturers, and they happen to be member of the cement manufacturer associations, and there have been allegations that this cement manufacturer association is either facilitating or blessing the coordination between and amongst cement manufacturers. So I have narrated you the kind of conduct which has received the attention of the Competition Commission so far as coordinated action of some of the players are concerned. Hitherto, as you know, these associations, so chemist and druggist associations, it is an association of chemists and druggists. They are not manufacturing, they are not selling the products. So this association doesn't have turnover. And they were getting scot-free on the ground that I am not an enterprise. So now law has been amended. And as I mentioned you, that an explicit provision about hub and spoke has been there. So these trade associations have been acting as hub, and spokes are their members. And so if there is any kind of blessing or facilitation by the trade body or by a common agent, I will give you an example. Many a times the bidders, they appoint a common agent to give the bids. So when common agent is coordinating bid of various bidders, that means the bid is being rigged. There is a common person who knows who is giving what. So it is a case of rigging of the bidding process. It is manipulated, and hence it is frowned upon, and it falls in the category of hub and spoke cartel. Now I'm coming on a slide which is of most relevant, that why we need to be conscious of competition law and why there is a need to comply with the law. So the commission can pass cease and desist order. It is an adverse sanction, and cease means don't do it, desist means don't repeat it. So cease and desist order, this power was already there under the MRTP Act with the MRTP Commission, and this power is also with the CCI, cease and desist order. But over a period of time, it was realized that the stakes have become so huge that mere cease and desist order will not suffice, will not correct, will not be deterrent enough. And this competition law provides for adequate penalties. These penalties are in line with the global trend, and the penalties are up to 10% of the turnover of the enterprise or up to 3 times of the profits. So if there is a case of coordination, if there is a case of cartelization, penalty up to 10% of the turnover as shown in your balance sheet, or up to 3 times of the profit as reflected in your balance sheet, penalty can be imposed. So that's why in cement cartel, penalty is approximately 6,300 crore against 11 enterprises, and it is at the rate of half time of the profit which they have earned in the year 2008, 9 and 2009, 10. It is half time they have imposed, while the power with the CCI is 3 times of the profit. But in case there is a violation of vertical agreement, or there is a case of abuse of dominance, then penalty can be up to 10% of the average turnover of preceding 3 financial years. And that's why you must have seen that DLF was punished at the rate of 7% of their average turnover in the last 3 preceding financial years, and it worked out to be 535 crores. The Competition Commission is also, and incidentally, if you are paying a penalty, this penalty amount is not a deduction under income tax law. It is not permissible deduction. It has to go out of the profit of the company. So the 30% deduction is not 30% the penalty profit and loss account. And the Competition Commission can direct modification of the agreement, and in case you are found to be delinquent, penalty up to 10% of the turnover as shown in your income tax return can also be imposed. And there have been several inquiries in the Competition Commission where penalties have been imposed on the individuals. But then there are 2 escape valves if the alleged delinquent director or the officer of the KMP, key managerial person, can demonstrate that I had no knowledge or I took due steps to ensure that there is no violation of the law. If you can convince the competition regulator that you had no knowledge or you took due steps, yet this contravention happened, commission may allow you to be, they can acquit you of the violation of the competition law. Now I have spoken about the penalty part, now appeal part and compensation. So appeal can be filed and penalty goes to the Government of India, Consolidated Fund of India. But if you have suffered loss or damage has been caused to you as a result of violation of the competition law, you can also file an application for award of compensation before the NCLAT. So after the order is passed by CCI and later it is endorsed by NCLT, after that stage, your case becomes matured to file a case for compensation. And if you are an aggrieved person, and if you can demonstrate that uh, you have been caused loss or damage has been caused to you, you can become entitled to a compensation. There is no limit on the quantum of compensation. Only requirement is you have to prove that so much loss has been caused to you as a result of indulgence in violation of the law. And if appeal from NCLAT, if you are unhappy with the order passed by NCLAT, appeal can be filed before the Supreme Court. Now, as a condition for filing of an appeal, 25% of the penalty imposed by CCI is required to be deposited with the NCLAT as a condition for entertainment of the appeal. Now, penalty guidelines have been issued, and these penalty guidelines are in public domain. Now, this is just to explain you that if you are kindly don't be under impression that that how the evidence will come to the notice of the CCI. Please let me tell you that circumstantial evidence is sufficient and convinces the Competition Commission. I will tell you a recent case which I have handled. Food Corporation of India floated tender for supply of certain tablets which they keep in the godowns where grains and rice are kept stored. So for their godowns, they required certain tablets so that rodent cannot eat away the grains and rice, etc. And they floated tender. In response, there are 3 suppliers. They quoted identical price. So as I mentioned, their scale of operations are different. Some companies are multi-product companies. Some companies are were manufacturing only single product. Despite so many heterogeneity, they quoted homogeneous, identical price. Now there is no trade association. There was no other evidence. But one most important circumstantial evidence which I am going to tell you was that the 3 regional managers of respective companies, they met at 1:20 p.m. at the reception of FCI office in Connaught Place. One of them made entry in the visitor register, and the gentleman who entered the entries indicated name of the person, designation, company, the mobile number, and email ID in the visitor register. So one made entries and the other 2 signed also in the visitor register, authenticating that the information which has been entered is correct one. So Competition Commission, later NCLAT, and later Supreme Court got convinced that this circumstantial evidence convinces more beyond doubt that there must be a discussion between or amongst them to meet at the reception of FCI office at a particular day, at a particular time. And also the fact that one records the description of the other 2, and the other 2 also authenticate the same, demonstrate that they were very much familiar with each other. And so this circumstantial evidence of making entry in the visitor register has been found to be sufficient to prove the case of cartelization, and more than this, identical price, which they have quoted. So invariably, it is our experience that if you are communicating by way of emails or through WhatsApp group, and the DG is empowered to retrieve and ask the email service provider to give all details. And so these details can be ascertained, can be checked. Invariably, in these cartel matter, it is seen that before the date of the filing of the tender or bid, uh, competitors speak on phone, and the discussions are invariably for longer duration. And subsequently, when we defend, when we argue, and we say that we have got social relationship because we are working in the same industry, CCI says that's fine, Mr. Bhatia, but kindly see that after the date of the tender over for 9 months or 10 months or 1 year, there has been no discussion. So that means discussion is there only when there is some substantive matter. So social relationship, the contention, the argument has not been accepted by the CCI. So now there is a case now, see, discussion about price. So if you are telephoning and you are saying wholesale price of gray cement bag is cheap, why don't we increase the wholesale price by 5%? So I agree. So from the, if you are increasing the price of your product, from the, if there is a synchronization of timing, if the extent of increase also synchronizes, then it is sufficient for CCI to get convinced that this circumstantial evidence is sufficient to prove that there has been some kind of meeting of minds and coordination. Punjab is our territory, do not sell your product in our territory. And then he says, Haryana is my territory, promise us that you will not sell. So these are, both are objectionable, sir. Then IOC has sought quotations for supply of gas cylinder. I will bid X price. Okay, we will bid X plus 5, but remember to return the favor in the next bid. Absolutely objectionable. You are rigging the bidding process. If so, it's a case of tie-up. If you want switches, you have to take cables from us. So switch and cable. Otherwise, we will have to stop supplying switches to you. That means switches are the fast-moving product, most wanted product, and cables may not be. And so they are insisting. So as you know, in the soap becomes a fast-moving item in the summer season, and the same product becomes a slow-moving item in the winter season. So if, and similarly, toothpaste is a fast-moving item, but toothbrush is not a fast-moving item. And invariably, leading toothpaste makers, they insist the retailer that, okay, we will give you toothpaste basket only if you buy toothbrushes also from me. So perhaps it a case of tie-up sale is there. So this practice is also objectionable. Now, recently, another provision, lesser penalty plus provision has been introduced. That means if already you are a leniency applicant and you come across another cartel which is not in the knowledge of the CCI, if you want to make additional disclosure about another cartel, you will get 25% additional penalty in the first case where you are an applicant, leniency applicant, apart from the benefit of disclosure of leniency applicant in another cartel. So this is a recent development. Ma'am, I think only 15 minutes have remained. So perhaps it will not be advisable to continue with the presentation. So if we can deal with question answers.
Yes, we are waiting for question answers. Right now, no such questions have appeared. So as and when some questions will pop up, I can share, sir. Let's wait for a while.
Okay, so what you suggest, should I continue?
Yes, so you can continue. Then if some questions will come, I'll just inform you or will ask. Let's wait for 1 or 2 minutes. You can continue with this slide. Then I'll get back to you, sir.
Right. So here is a case of vertical agreements, Shamsher Kataria versus Honda CL and others. You know, in the car industry, it's a unique industry. In car industry, the experience of CCI is that when a car company, car manufacturer enter into any agreement with a component supplier, there is invariably a restrictive clause which provides that, hey, component maker, kindly note whatever you will produce, you will give it to me and you will not sell in the open market. So if there is a component supplier, take the case of Maruti Udyog Limited. Maruti procures so many parts, several parts from the open market. They procure tires, they procure various components which are fitted in a car. So some are making gears, some are making wipers, some are making other gadgets which are fitted in the car. And so on the component suppliers, there is invariably a restriction that you will produce the quantity which I will mandate you, and you will not sell in the open market, and you will supply the entire production to me or to my authorized outlets. This is the ordinary practice in the car market. And so component makers are forbidden not to sell in the open market and make supply either to the car company or to their authorized dealer or authorized service centers. And on the other side, when Madam Amita purchases the car, there is a condition, ma'am, please note, you will not get fitted any unauthorized spare part from Kashmiri Gate or from Karol Bagh in your car. In case you get it fitted or you get serviced your car from any roadside mechanic, then my warranty guarantee will not be there. So on the one side, see the restriction on the car component supplier, and on the other side, see the prohibition on the innocent, meek, submissive customer. That customer is forbidden to purchase to get fitted any spare part or get service car from any person other than authorized by the company. So, ma'am, CCI, the DG office undertook an investigation on this aspect, and it came to the analysis that an I-10 car, which is ordinarily made available for 9 to 10 lakh rupees, if I happen to be an assembler and I want to assemble I-10 car, and if I purchase all spare parts required for making I-10 car from the authorized outlets, then it will cost me around 60 lakh rupees. That clearly shows that the spare parts which are being supplied to you and me are being supplied at almost 7 times at a higher price. So
Now, sir, can we take some questions?
okay.
So, first question that comes is that what role do CA play in advising clients on competition law matters?
Say it again.
What role do chartered accountants play in advising clients in competition law matters? Like how they can include in this?
Absolutely. I think it's the most relevant question and I should have covered it. But unfortunately, even I could not complete my whole presentation, and only one limb we are close to complete. Anyhow, I think chartered accountant has got a very, very extremely important role so far as compliance with competition law is concerned. First, you have to assess, you have to ask first you have to understand the business of your client. What he does, how he does business, what kind of arrangements he has. So there is a need to undertake business analysis from the lens of competition. We need to first where from he buys the raw material which it requires to make its products. So as a buyer, if the client is a buyer of certain products, it should be ensured that there is no collusion, no coordination amongst the raw material supplier. Why? Because if raw material suppliers are in collusion or in cartelization or bid rigging, that means your client is not receiving inputs at the competitive prices, and hence it becomes very difficult for that client to compete in the market. Similarly, the profit margins will be substantially reduced if I am buying product at an uncompetitive price. Secondly, then we have to see the selling part also. Selling part is that what kind of marketing arrangement I am having. Is it that my client is selling directly to the end customer? Is it that the government is the purchaser? Is it that I have got a mechanism of selling through distributor? Or is it that my client now requires the services of e-commerce platform? So if you are selling directly, then you are the supplier and you have got more liberties so far as pricing part are concerned, so far as discount parts are concerned. But if you are selling via distributor through stockist, etc., that means you have already sold the product, and then you should be shy of entering in controlling any stockist, their freedom. If you are controlling your intermediary freedom, that means you are inviting trouble for your client from the competition perspective. If you are selling the product via e-commerce, again you have to ensure that e-commerce player is not indulging in a practice of, because in e-commerce the business is very complicated. In traditional market there is a buyer and a seller. In tech markets there is a service provider, then there is a seller. Then, as you know, in the case of some of the e-commerce players, they prefer their own product. They show their own product instead of a non-related supplier, and hence such kind of treatment can give rise to competition concerns.
One more question.
Yeah, similarly, if your client is a member of a trade association, please ensure that member, when it participates in the trade association, he is accompanied by or he takes advice of an antitrust lawyer. When you give information, competitive sensitive information to a trade body, you have to be very conscious. If you are giving your production figure, if you are a listed company, you are inviting trouble, because that quarterly report, before it comes into and shown on the stock exchange, if it is shared with the trade body, you are violating both SEBI law as well as competition law.
So there's another question from the participant. Let me read it out. It's from Nitin Praveenchand Doshi. Are exclusive franchisee agreements covered, or exclusive outlet shop of a company be covered?
Yes, so they are covered, but then if there are commercial justifications and if you can demonstrate that the advantages to the end customer, to the market, outweighs the disadvantages. So exclusivity is not per se bad, but you need to build a justification in the agreement itself, so that when it is read by the competition authority at your back, they are able to understand what are the commercial nuances. What is that which persuades you to impose this restriction in your franchise agreement?
So one more question from Srijit Kumar Basu. Does the statutory auditor have a responsibility to advise their clients on compliance with competition law, or to otherwise check that client has complied with the competition law? So is it coming under the review of statutory auditor?
As a statutory auditor, I don't see there is any legal obligation. But since you are a statutory auditor and you are equally interested in the growth of that client, so since the penalties are huge and more than financial penalty, it is their reputation and goodwill which they have earned over a period of time. It becomes a playground for a competitor to exploit that situation. Uh, Perhaps I feel that you can have a better, it will create a better perception in the mind of client if you sensitize the client about the potential violation of the competition.
So one more question. Are exclusive agreements automatically anti-competitive?
Absolutely not. As I mentioned time and again, that they are not per se bad. In case that exclusivity results in appreciable adverse effect on competition, only in that situation it can be dubbed as anti-competitive.
And sir, how do we scrutinize that digital marketing for competition things? Like you were telling about e-platforms now. So how you scrutinize that digital market?
So, ma'am, some of the inquiries are going on in the field of, you see, I have mentioned you the case of Google. Similarly, there is an inquiry going on against Amazon and Flipkart. Likewise, there are certain inquiries against food delivery outlets. Similarly, in the booking of the rooms, etc., uh, some inquiries have been conducted. So, in high-tech giants businesses also, anti-competitive or abuses clauses are there, and so clauses are almost the same, but it's slightly difficult to detect and to investigate. But inquiries are going on under the existing competition law.
So right now, these were the set of questions we got. So if you permit, we can conclude, sir.
Yeah, absolutely. Thank you very much for the time.
Sir, Sanjay sir is just coming. Just a minute.
Okay. So our chairman is again joining us, sir.
So nice of you. Thank you. I will wait.
Yeah, I'll wait if some more questions there. We can handle more questions if it's coming up. Can you enlighten us for this deep discount which is offered by company? Is it an abuse or something constitutes?
Yes, deep discount is objectionable because the regulator feels that these are because of the deep pockets, you are able to give deep discounts. So there is a concept of predatory pricing. If the cost of the product is 100 rupees and you are offering at 70 rupees, you are selling below the cost of production. Give a deep discount of 30%, and invariably it is not an introductory offer. That is if it is given by a dominant player in the relevant market, then it can be with the intention of eliminating competitor from the market. So if it is with the intention to eliminate competitor, certainly it is objectionable and it is an abusive conduct.
So we have with us our chairman of the committee, Sanjay Agarwal.
Right, sir.
So over to you, sir.
So, okay, sir, you have given a detailed analysis, and as you know that in Issued, we are expert now in multitasking. So in between, I bunked for some time. However, I continue to have my AI agent to listen to you, and the way you have explained the various provision and practically telling them that how to handle the situations and where the opportunities are there. I think normally chartered accountants, they do not think that competition is the cake for them, because this is a very specialized area and since stakes are very high. But however, the chartered accountant can help in preparing documents, also in the helping the various professional, those who are expertising in this Competition Act. And that's how Mr. Bhatia was successful in explaining us. Also, I say that whenever we draft an agreement or we have some pricing mechanism of the clients, because now when we are auditing also, we have to see that after the audit is being done or while doing the audit, if certain things are not checked by us, the clients can come in problem. So with this, Bhatia sir, thank you very much for devoting your 2 hours to the ICI. And we have also taken your help in various other tasks also. Thank you, Sarita, for moderating the session and taking the question in a very in different manner. And also, sir, Bhatia sir, have you finished or yet 1 or 2 slides are there?
Sir, I think it will take. I have got certain more, sir. But I think you give me another opportunity to speak on digital competition law.
Okay.
Then I think it will be a complete course, because that's an upcoming law. Worldwide, clients are facing problem and people have got a lot of ambiguities, and it requires clarification. So,
Mayank, please note down sir's suggestion. And Amita also, when
Noted, sir, noted.
Yeah, when you give the feedback on this, kindly see to it that in the next session also you are moderating and Bhatia sir will enjoy.
Yes.
So thank you very much, Amita. And can we close down office?
yes, sir. My thanks also, sir, to you, to Vice Chairman Amita ma'am, and Mayank also, sir. It has been possible only because of your help and good wishes. Thank you very much.
Thank you. Thank you.
Thank you
Stay
so much,
safe,
sir.
stay healthy. Bye.
Thank you, sir.
Thank you, sir. Thank you, ma'am.
Thank you.
Tech support, please.